Good evening and welcome to the New York State Trustee Handbook Book Club. I'm your moderator for the evening. I'm Brian Hildreth. I'm so excited all of you can be here with us this evening for a deeper dive into the topic of open meetings law. For those of you joining us for the first time, the Trustee Handbook Book Club exists to empower New York's 6,000 plus library trustees with the knowledge and tools that you need to excel in your role of governance and championing for your library and your community. Before we jump in, and I can see all of you are doing this already, let's get to know each other a little bit better. Please drop a quick intro into the chat. You can put your name, your library that you serve within, and how long you've been on the library board. It's always fun to see where everybody's zooming in from, and it's always nice to see all those repeat names that have been joining us for the ride for the last 6 years. Tonight's session is made possible through our partnership with the New York State Library, the Public Library System Directors Organization, the Library Trustees Association, and the Public Library section of NYLA. We are grateful to their continued support in bringing these valuable learning opportunities to trustees all across New York State. So here's our agenda for the evening. First, we'll explore tonight's topic with our expert presenters. Then we'll tackle your pre-submitted questions. Following that, we'll open up to a live Q&A with real-world experiences and questions always make for the best discussions. On a quick tech note, use the Q&A button at the bottom of your screen for questions, and feel free to share your thoughts and experiences in the chat. Supporting us tonight is the ever helpful Laura Chrissy from the Mid-Hudson Library System. She is our technical support and will share information out as well as links as we go through the night in the chat section of the meeting. Also joining us is our fearless leader of the Trustee Handbook Book Club and CEO, Rebecca Smith Aldrich. I'm going to turn it over to Rebecca in just a moment because she's going to do a fantastic introduction for our guest speaker. We're all excited to introduce Kristen O'Neill, who is coming from the Committee on Open Government of New York State. It's wonderful to have Kristen here with us this evening to break down the nuances of open meetings law, especially now that we've moved further away from the pandemic and our communities require libraries that maintain the public's trust through transparency and excellent library service. Rebecca, Kristen, thanks so much for being with us here tonight and sharing your expertise. We look forward to learning from all of you and growing as a library community.
Thank you so much, Brian. Oh, and thanks to everyone who's here tonight. We really appreciate you making time to learn more about your role as a public library trustee and an association library trustee. You know, we've done this topic before, and some of you might recognize Kristen. We've seen her in the past, but we've noticed over the years that we've been doing the Trustee Handbook Book Club, questions about open meeting law persist. And so we thought, let's bring Kristen back. We think people might enjoy learning from her. And there certainly was a bit of confusion as the law shifted and accommodated during COVID, and then we shifted out of what we call the COVID era of open meetings law and into where we are today, which includes some slight updates to open meeting law over the past 7 years, as well as that change to the rule about video conferencing. So I'm thrilled to introduce Kristen, and I want to say just quickly, when we get to the questions and answers, I'll help out Kristen in case anything very technical about library law, quote unquote, library law comes up that's outside of Kristen's area of expertise. But for the most part, you're going to be hearing from Kristen tonight. And I looked back, Kristen, I know I've been getting help from you for the past 10 years. So
yeah,
if
it was
I'm mistaken,
10
this
years
is
in
your
November that I started with the committee. Yep.
yeah, 10-year anniversary of helping out organizations like libraries across New York State to understand the letter of the law of open meetings law and to not run afoul of it. As Brian said, as we always promote here at the Trustee Handbook Book Club, our goal is to have transparent, accountable libraries that really are doing the business of the public in an open and transparent manner. As you've heard me say many times in the past, there's no easier way to lose the trust of your public or your staff at the library than abusing open meetings law, not announcing meetings, incorrectly using executive session, not posting documents on your website. They're all such easy things to comply with. And when you don't do it, it can create an exponential amount of problems for you. So we're thrilled to have Kristen here. She's going to walk us through the basics of open meetings law. She is very up on what some of the most frequently asked questions are for libraries. And then you will also have time to ask questions. So just that reminder, use the Q&A feature to precede your questions, and we'll do our best to get to as many as we can while we're together tonight. But I'll turn it over to Kristen, who is the real reason you're here tonight. Let's be honest. So Kristen, please go ahead.
Well, thank you for having me tonight. I warned Rebecca and Brian and Laura earlier. I said I got like a house full of dogs and cats. right now. So if at any point I just may need to like let dogs in or out of the door, but I promise I will keep it brief and not try to interrupt our program too much. Um, so tonight we're going to be talking about the open meetings law and specifically sort of the little quirks related to how it might apply to, for example, association libraries that are brought under the umbrella of the open meetings law, not so much because they're considered a government agency or a public body as defined under public officers law, but because there's a provision of education law that requires those libraries, all libraries, to comply with the open meetings law. So that's a little bit of a quirk that is very specific to libraries. So we're going to talk about situations that apply to all public bodies generally, but also to libraries and association libraries. I got married in October, and I'm in this process of switching over my name. So I feel funny. I was like, I'm not quite sure who I've told my where I've changed it and where I haven't, but don't worry, my email remains the same. So if you've ever reached out to me at kristen.o'neill@dos.ny.gov, that's not going to change. I'll keep it until I retire because it's too complicated not to. In addition, we're a small office, the Committee on Open Government. We're housed within the Department of State. We have our executive director, myself, two senior attorneys, and our administrative assistant. That's the entire staff of the Committee on Open Government. If you have questions, and it's not something specifically you need to talk to me about, the best way to get a very quick answer to your question is to email our office address, which is this COOG@dos.ny.gov. It's the acronym for Committee on Open Government. Email that email address or just call that telephone number and ask to speak with an attorney. In addition, there's tons of helpful information on our website, the opengovernment.ny.gov website. So if you go to the website, you'll see, like for example, at the top of the screen, there's these drop-down menus where you can see under the Freedom of Information Law, there'll be links to the statutory text, regulations, advisory opinions, where right now on the screen you see where it just says Committee on Open Government. If there's anything sort of new that's happened in the world of open government, we're going to get that up there on our primary screen. In addition, if you would like to be added to my mailing list, I promise I don't spam. You're not going to be getting multiple emails a day or even multiple emails a week. Honestly, it's probably only a handful of times over the course of a year I'll send out emails to anyone who has asked for that information, letting them know about something sort of, maybe there's been an amendment to the statute, to either the Freedom of Information Law or the Open Meetings Law, or maybe there's some very significant case law that really affects how we handle meetings under the Open Meetings Law or requests under the Freedom of Information Law. Anything like that, I do. If we're going to put something up on our website, I'm very happy to add you to my mailing list, and I'll just notify you when things like that occur. In addition, we have this section of our website that takes you to different areas of guidance. Like, for example, many of these things do relate to the Freedom of Information Law as opposed to the Open Meetings Law. But if somebody's looking for help about, how long do we have to respond to FOIL requests? How do I make a FOIL request? That type of information is available on our website. In addition, a couple of times a year, I do virtual programs just like this one, but I would say a little bit more generic. And I record those programs and I put them up on our website. So in the lower right-hand corner, you see a section that says View Training Materials and Recordings. So if you're ever looking for maybe like a refresher, or if you know somebody who's looking for a refresher on FOIL or the Open Meetings Law and they weren't able to attend these fun programs, you can point them here. So the Open Meetings Law is codified in Public Officers Law. It's Article 7. So if you ever see references to Public Officers Law when we're talking about the Open Meetings Law or the Freedom of Information Law, that is why, because that's where the laws are codified. The law was passed in 1976, and the declared legislative intent was that public business should be performed in an open and public manner, and that citizens should be fully aware of and be able to observe the performance of public officials. In addition, the law says that the citizens have the right to attend and listen to the deliberations and decisions that go into the making of public policy. So it's not just about voting. It's not just about being able to go to a meeting and watch a board of trustees vote on particular issues. It's about actually watching them debate and have a discussion that leads to the decisions. So a lot of times I think Rebecca sent me some questions, and I know one of the questions was like, well, can we have brainstorming meetings that are not subject to the open meetings law? And I'll tell you right now is the answer is no. That's the whole point of the open meetings law. These conversations about the back and forth, the pros and cons of particular issues, those types of conversations are required to be held in a meeting that is held in compliance with the open meetings law. Who is required to hold their meetings in compliance with the open meetings law? This screen became much more overly complicated due to a legislative amendment about 4 years ago, but I will try to break it down into sort of simple chunks to make it easier. So when we're talking about public bodies, for your purposes, all the people here on this program, a library board of trustees is a public body. Some of you are public bodies, or some of you are members of public bodies, because the Public Library Board of Trustees meets the statutory definition of performing a governmental function for the state or for a municipality. So for example, if you have a town or a city public library, a school district library, those are all governmental entities where the Board of Trustees meets the statutory definition of public body under the open meetings law. But in addition, there's a provision of New York State education law, section 260-A, that states that every meeting, including special district meetings of public libraries, cooperative library systems, public libraries, or free or association libraries. So essentially all libraries. So if you are on a board of trustees for a free library or an association library or a public library, all of your meetings need to be held in compliance with the open meetings law. There are a couple of particular considerations that relate just to free and association libraries, but I'm going to circle back to that in just a moment. So public body, you have your board of trustees. Your board of trustees is a public body that must hold their meetings in compliance with the open meetings law. In addition, if, for example, you have a 7-member board of trustees, that 7-member board of trustees is a public body. In order to conduct a meeting, you must have a quorum present, and a quorum of a public body is the majority of the total membership if there were no absences or vacancies. So if you're supposed to have a 7-member board of trustees, a quorum is always going to be 4, regardless of whether you currently have 7 people on the board or not, regardless of whether 7 people show up to the meeting or not. You need to have 4 people present at a meeting to even get the meeting started. And in order to pass any motion or resolution, you would need 4 members to vote in favor. So that's what we mean when we talk about quorum. In addition to the Board of Trustees, if the Board of Trustees designates a committee or a subcommittee that is made up entirely or primarily of members of the public body, so let's say, for example, you have a finance committee that is made up of 3 of your members of the Board of Trustees. That finance committee is also a public body that must comply with all aspects of the open meetings law. But this only applies to public libraries. This is where one of those tweaks that I was talking about comes into play. So in general, when you're talking about, for example, county legislatures, city councils, town boards, village boards, that rule about committees applies to all of them. It also applies to public library boards of trustees. If you have a committee that is made up of members of a larger public body, and it is a public library, that committee has to hold its meetings in compliance with the open meetings law. The same is not true if you serve on a board of trustees for a free or association library. In other words, like a not-for-profit library. Because the provision of education law that makes free and association libraries subject to the open meetings law specifically states that only committee meetings where the city that sort of, I guess, the city that hosts that public body has 1 million or more people, in other words, New York City. Let me just keep it simple. Unless your free or association library is located within New York City, then your free and association library committee meetings do not need to be held in compliance with the open meetings law. You can have your meetings in any way you see fit because they are not, the committees and subcommittees are not subject to the open meetings law. So yes, I know that was a little bit complicated going back and forth between the two slides. That is that sort of weird distinction when we're talking about the distinction between boards of trustees for public libraries and those for free and association libraries.
Hey, Kristen, I'm sorry to interrupt you. We've got a few folks that are having trouble seeing your slides. We're
Oh,
seeing both your photo and the slides themselves. We were wondering if you might try to reshare with just your slides.
all right, let's see.
And if it works, it works. And if it doesn't, no worries. We'll just keep going.
That's, what I'll do is I'm gonna,
So while Kristen's working on that, I'll just say to everyone, you will get a copy of the slides as a follow-up email, the way we normally do. So if you're having trouble reading the slides, please know, listening to Kristen, you're getting the same information, but we will follow up with a copy of the slides. If this works out, this reset of the share, great. But like I said, if not, we'll keep going.
sorry, let me just, I'm gonna pull up, make that big again. I wanna do more, I wanna do share. I don't want to share the screen. I just want to share. I was hoping that there is, oh, here we go. I think this might work better. I'm hoping that this will work better. And then we'll do this. Can you tell Rebecca if that is better?
No, it looks the same as it did before, but like I said, we can just roll with it, and we
Oh,
promised everyone they'll get a copy of your slides.
oh, I wish I could make it so it's not blocking anyone's view. I'm not sure. Let me just try one more thing.
Okay,
I'm going to
thank
do
you.
instead of, that didn't make any difference, I'm assume.
Looks the same.
Instead of sharing the presentation, I want to try sharing my screen. Did that make any difference?
Nope, looks the same.
I'm so sorry. I can't even figure out
No,
myself what's
really,
wrong.
Kristen, like I said, like people are saying, it's not terrible, it's just small, and we promise them they're going to get the slides, and you really are saying exactly what they need to know. So hopefully folks can really focus on what you're saying and take comfort in knowing they're going to get the slides in their hands.
Exactly. So apologies for that. All right. So let me go back and skim forward to where we were before. So one of the things that's really continues to be somewhat of a bit of a complicated issue because it's newer and there's a couple of hoops that you have to jump through. Is that we're going to talk about video conferencing in the beginning. During COVID, of course, as we all probably remember, even if you weren't serving on a board of trustees at the time, there were executive orders at the time that suspended a public body's obligation to hold their meetings in person. So, for example, if you wanted to go to a school board meeting or a town board meeting, those entities were not required to have in-person meetings. If they chose not to, they could have completely remote meetings. As the health emergency sort of started to get better, the risk wasn't as high. We started moving back towards in-person meetings. But everyone sort of realized, wow, having these remote meetings was convenient, was wonderful. It actually was great for both members of the public body and for members of the public generally, because you could, stay at home instead of having to drive out to maybe a school board or a town board meeting. You could just watch it online. So there were a lot of benefits of having remote meetings. So the legislature took this under consideration, but was very hesitant to move away from the obligation to have in-person meetings. So there is still that obligation. All public bodies must continue to have in-person meetings. However, now we have, in addition to the ability to use video conferencing the way we had been able to use it prior to COVID, there's a new way to use video conferencing as well. So I sort of refer to it as the pre-COVID and the post-COVID, or the pre-COVID and extraordinary circumstances way of video conferencing. The pre-COVID way, which has existed for 25 years now, has allowed public bodies to have meetings where you have members of the body present at multiple physical open locations that are connected to the use of video conferencing. And with my experience, it's easiest to use my own personal experience. The Committee on Open Government is a statewide board. We have people that are serving that live all over the state of New York. We're an 11-member body. Some people live in New York City. Some people live in Western New York, Central New York, Albany area. So when we have a meeting, we take advantage of Department of State locations throughout the state, generally either Buffalo or Syracuse, and then New York City and Albany. And our members can choose the location that is most convenient for them. And if the public wishes to, it can choose the in-person location that's most convenient for them to attend the meeting. And then all of those locations are connected to the use of video conferencing. So we might have a couple of people in, hold on. I wasn't sure if starting my video, I didn't know if the video was having any impact on on the view of the slide. So that's why I turned that off, but I don't think it had any impact. So anyway, you could connect all those sites to video conferencing. You could have some people in different parts of the state. All of the locations had to be included in the meeting notice. All of those locations were open to the public and then just connected through the use of video conferencing. Then COVID came along, and the post-COVID, the extraordinary circumstances video conferencing allows the use of video conferencing in a much more limited way. It establishes very detailed procedures for if a public body wants to take advantage of this provision. There has to be a proposed resolution, a public hearing. There has to be policies established. If you want to take advantage of this provision, it was a very lengthy addition to the open meetings law just to address this sort of expanded use of video conferencing. But what it does is it allows a member of a public body to participate from a private location, like their home or maybe their office, a location that's not included in the meeting notice, a location that's not open to the public, but they're only allowed to do this if they are experiencing an extraordinary circumstances. What is an extraordinary circumstance? The open meetings law defines it as disability, illness, caregiving responsibility, or any other significant or unexpected factor or event which precludes the member's physical attendance at such meeting. That's how the open meetings law defines extraordinary circumstance. So you can see it's pretty limited. It's not intended for situations where somebody is on a work trip. It's not intended for situations where somebody is on vacation. It's really sort of those significant and unexpected factors. And as the legislature itself used the term extraordinary. So it's not really meant to deal with sort of day-to-day inconveniences. It's really intended to be only a very limited use of video conferencing that would allow somebody to attend from a private location. Again, as I mentioned, if your body wants to do this, you have to pass a resolution, you have to have a public hearing, you have to establish written procedures, and those procedures have to be consistent with the obligations under the statute. In terms of quorum, if you are using this extraordinary circumstances video conferencing, you still have to have a quorum of your members present at an open physical location. So again, if you have a 7-member board, you're going to need, with one exception that I'll talk about in a minute, you're going to need at least 4 of your members present at that, for example, at the library, at the public location that where people can actually show up and see you in person. Who counts towards a quorum under this provision? First, members participating from an open physical location are count towards a quorum. Second, there was an amendment to the law in 2023 that says if your extraordinary circumstance is disability, as defined under New York State executive law, only if your extraordinary circumstance is disability, then you can count towards a quorum. Who doesn't count towards a quorum? If your extraordinary circumstances is illness, caregiving responsibility, or some other significant or unexpected factor that prevents you from attending in person, you do not count towards a quorum. Who can participate? Obviously, if you count towards a quorum, then you can also participate. So if you're participating from a physical location that's properly noticed and open to the public, then you can fully participate, and this includes voting. If you are participating from a remote location due to an extraordinary circumstance, you can fully participate and vote as long as a quorum has otherwise been satisfied. So that's my brief spiel. Well, I shouldn't say brief, it's kind of a lengthy spiel, but that's my spiel on the use of video conferencing for meetings. And again, if we do have more questions about that, because I understand it's a little bit convoluted in places, we can talk about that at the end. So now we'll move on to sort of the more general obligations under the open meetings law. Notice. Notice of every meeting subject to the open meetings law. This includes the Board of Trustees, and if you're a public library, notice of meetings of committee meetings or subcommittee meetings must include date, time, location, and if appropriate, instructions for virtual attendance. Notice must be provided prior to every meeting, must be given to the media. This doesn't mean you need to purchase a legal notice. It just means you need to notify the media, whether it's by email or antiquated fax or whatever the case may be. There's no obligation actually that this notice be in writing. My sincere recommendation is that you do put it in writing. That way you have sort of protection for yourself that the notice took place, that the notice occurred. Another sort of antiquated obligation under the statute, in my opinion, I guess, maybe not everybody thinks it's antiquated, but there's an obligation that the notice be placed in a designated physical location. I don't know that there's a lot of people that continue to look at a library bulletin board to find out when meetings are taking place, but it's possible because a library is a place where there's a lot of in and out traffic. So it's a little bit different, for example, than a town hall or a city hall. There's a lot of in and out traffic with a library, so it might be more common for libraries than in other entities. The notice has to be placed in a designated physical location. And if your agency or public body has an active website, notice of your meetings has to be posted on the website. In terms of timing, in general, that notice has to be provided at least 72 hours prior to the meeting, any meeting that is scheduled at least 1 week in advance. Education law, section 260A, however, states that, that there is a provision. The education law reference in 260 is a little bit dated. So when they talk about section 99 of the public officers law, they're essentially talking about the open meetings law. It's an incorrect citation, but it's the open meetings law. So education law says that public notice of the time and place of a meeting scheduled at least 2 weeks prior must be given to the public and news media at least 1 week before the meeting. So for libraries, there's an additional statutory obligation that doesn't exist for all other bodies. For meetings that are held on short notice, for example, if a meeting is scheduled less than 1 week in advance, notice must be given to the extent practicable at a reasonable time prior to the meeting. the law itself, the open meetings law itself, is silent as to when a public body is allowed to have meetings on short notice, but the courts have weighed in, and the courts have said that really it's only okay to have meetings on short notice if there's an actual need to do so. If for example, if some sort of harm would be caused by waiting until either the next regularly scheduled meeting or waiting until you can provide that minimum of 72 hours notice. They don't want public bodies to be having meetings on short notice willy-nilly without any real good reason for doing so. Records scheduled to be discussed. This is an obligation that's been in effect for 14 years now, and but it was amended about 4.5 years, 4 years ago, 4.5 years ago. So the obligation that's been in effect for quite some time is that records scheduled to be discussed during an open meeting are supposed to be made available prior to the meeting. It used to be, the law said that that those records had to be available prior to or at the meeting. The amendment in October of 2021 requires that those records be made available to the extent practicable at least 24 hours before the meeting, if the agency maintains a regularly and routinely updated website and utilizes a high-speed internet connection. So most libraries, I think in this day and age, really do use their websites as tools for reaching out to the public, making information available to the public. If you do have one of those websites, then your the records that your board plans to discuss during the meeting, during the open portions of a meeting, must be made available to the extent practical at least 24 hours prior to that meeting. What types of records are we talking about? Specifically, the law identifies proposed resolutions, laws, rules, regulations, policies, or any amendments thereto. A little bit more broadly, the law also talks about just any record or portion of a record that would be available under the Freedom of Information law that the Board of Trustees plans to discuss during the open portion of a meeting. This does not apply to records discussed in executive session. So, for example, if there's litigation or if you're reviewing resumes for a library position where you want to have that conversation in executive session, the records that you plan to discuss in executive session do not need to be made available to the public in compliance with this provision. It's just open session. Minutes of a meeting subject to the open meetings law must include a record or summary of all motions, proposals, resolutions, or any matter formally voted on and the votes thereon. So for it's very bare bones. Many public bodies include more than that. It's completely within the discretion of the body or the person who's been designated to take minutes if they want to include more. It's just about sort of establishing a consistent policy about what type of information you do include in the minutes and what information you don't. You don't want to be in a situation where for example, if you are providing summaries of public comment, you don't want to include summaries of public comment that are favorable to the library or favorable to library board positions, but then leave off the ones that are not favorable. That's just sort of basic, I guess, common sense about that. But all the law requires is that you include a record or summary of the motions, proposals, resolutions, and any other matter formally voted upon and the votes thereon. There is a provision of the Freedom of Information law that only is going to apply to public libraries that requires that every public body is required to maintain a record of how each individual member voted. So if you have a resolution that passes unanimously, minutes reflecting that it passed unanimously is going to be sufficient. But if there's some type of split vote, there has to be a record that shows who voted in favor of a motion or proposal and who voted against. If extraordinary circumstances video conferencing is used, there has to be a record of which, if any, members participated remotely. A public body is only required to take minutes of an executive session if the public body votes in executive session. If your board is merely deliberating in executive session, but then waits to vote until they come out into open session, there's no obligation to prepare separate minutes or to prepare minutes of the executive session if the vote does not occur in executive session. In terms of timing, those minutes must be made available within 2 weeks of an open session, and if necessary, 1 week for an executive session. Doesn't matter whether those minutes are still unapproved or still in draft form, they still need to be prepared within 2 weeks and made available within 2 weeks. So for example, if someone made a request for copies of the meeting minutes, even if they haven't been approved yet, they would need to be made available upon request. And in addition, the law was amended in the fall of 2021 to require that all public bodies that have the ability to do so have to post their meeting minutes on their website within 2 dates of the meeting or 1 week of an executive session, if a vote occurred in executive session. So again, even if those minutes haven't been approved yet, even if those minutes are still draft because the board hasn't had a chance to look at it, they still need to be posted online. They can be marked draft, they can be marked unapproved, but they still would need to be posted. With the caveat that there is provision of the open meetings law that allows a public body to post an unabridged audio or video recording or an unabridged transcript in lieu of posting meeting minutes, but this does not relieve the public body of the obligation to prepare the minutes within 2 weeks. It just relieves the public body of the obligation from posting those minutes within 2 weeks. That's the only difference there. So some people get confused. They think, oh, well, we've got a recording, we don't need to prepare minutes. That is not accurate. You still need to prepare minutes, and you still need to prepare minutes within 2 weeks of the meeting and make the minutes available upon request within 2 weeks of the meeting. It's just that if you would prefer to post an unabridged audio or video recording or an unabridged transcript instead of posting, say, for example, unapproved meeting minutes, you would be permitted to do that. Recording. Any meeting of a public body that is open to the public shall be open to being photographed, broadcast, webcast, or otherwise recorded and or transmitted by audio or video means. So if you have a member of the public that comes to your meeting and they would like to take photographs or they would like to record, whether it's with their own personal smartphone or with a video camera of some sort, they have the statutory right to do so. They don't need your permission. They don't need to give you advance notice. They can just essentially show up and take pictures. They can show up and live stream. They can show up and record. They have that statutory right. The library can establish reasonable rules to limit disruption and interference. So for example, if someone does come in with sort of larger video equipment, you can have maybe established places within the room where that video equipment should be placed so it's not disruptive to the meeting. The library itself is not going to be obligated to record its meetings unless one of its members is participating remotely under the extraordinary circumstances video section. I'm going to step away for just one moment. I'll be right back. Sorry about that. As I said, dogs and cats. So now we're going to talk about executive session. There are two provisions of the open meetings law that allow a public body to meet behind closed doors. The most commonly known one is, or the most people are more familiar with, is executive session. All types of bodies have executive session. It doesn't, it's not specific for example, to public bodies under the open meetings law. It could be not-for-profits, it could be corporations. Executive sessions are used in all sorts of meetings. But there are very specific rules under the open meetings law as to when a public body is permitted to have an executive session. First, it's important to remember that an executive session is a portion of an open meeting that is not open to the public. It's never prior to or separate from an open meeting. For example, you can't schedule an open meeting for 7 p.m. and have your executive session at 6:30 p.m. You cannot have a 100% scheduled executive session. You can have an open meeting that is publicly noticed, where the public is invited to attend, and within 1 minute of opening your meeting, you can make a motion to enter into executive session. If that motion passes, you can go into executive session for the remainder of the meeting. That's fine, but you still have to have an open meeting in the first instance in order to make the motion to go into executive session and to vote on that motion. The motion to go into executive session has to be specific. It has to identify the topic or the topics that you plan to discuss in executive session, and it has to be specific enough to reflect to fellow board members and to the public that you're going into executive session for a proper purpose. The courts have spent quite a bit of time on this issue. It may be one of the most frequently litigated topics under the open meetings law is when public bodies are not entering into executive session by providing sufficient information. That motion can't be just litigation, personnel. You can't just like throw out sort of key words and think it's enough. The courts have repeatedly held that you need to be more specific than that. But you don't need to be so specific that you're defeating the purpose of the executive session. So up on the screen right now, and I know some of you are having a hard time seeing it, but don't worry. Again, all this information will be shared with you. And if you ever have questions, you can follow up with me. The reasons that a public body are permitted to go into executive session are up on the screen now. If you don't see it in the statute, this is pulled directly from the statute. If the reason for entering into, if the topic you want to discuss isn't in here, it likely means that the conversation needs to occur in public. Some of the very common grounds for going into executive session. The first one is discussions regarding proposed, pending, or current litigation. This allows a public body who is either being sued or has brought litigation against another party to discuss litigation strategy, maybe possibly settled negotiations relating to that litigation in executive session. It protects the public body's sort of legal negotiating power to some extent, that they can have those conversations behind closed doors. But you should keep in mind, it's about having conversations relating to the litigation. It's not about having conversations relating to the topic that led to the litigation. Sometimes we've had issues brought to our attention where a public body wants to discuss a sensitive topic in executive session because they fear they are going to be sued. That does not matter one iota. The fact that a public body may end up getting sued based on a decision they make is just sort of the cost of doing business in government. There's no protection against that. It does not mean that those conversations don't need to occur in open session. What you can discuss is the litigation strategy. Oftentimes you'll hear public bodies say they're going into executive session to discuss personnel matters. That is not sufficient language. Courts have repeatedly held that is not sufficient language. The language from the statute is very unwieldy. And I'm not really recommending that you just pluck the language from the statute either. The courts don't want to see that as well. It's just that the language from the statute gives you parameters for what you're allowed to discuss. you look to the parameters that are set forth in the statute and you pluck the portions that apply to your scenario. So let's say, for example, you have a position that has opened up at the library, maybe it's an executive director position, and you're reviewing resumes. And you as a board want to discuss the resumes that you've received to see which ones you maybe want to pursue in terms of calling in for interviews, things of that nature. So the language from the statute that allows you to go into executive session is discussing the medical, financial, credit, or employment history of a particular person or corporation, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. Again, it's a mouthful. So what you want to do instead is say, or move to go into executive session to discuss the employment history of particular individuals and matters leading to the appointment and employment of one or more of those individuals. That's one example. Maybe you've had allegations of misconduct brought against one of your employees, and you're going into executive session to discuss that. You would make a motion to discuss the employment history of a particular person and matters leading possibly to the discipline, suspension, dismissal, or removal of that person. You do not need to identify the person. You don't need to identify the people that applied for the executive director position, and you do not need to identify the person who is subject to allegations of misconduct. You just need to provide enough information to board members and the public to show that you're going into executive session for a proper purpose. Exemptions. This is the second avenue for meeting behind closed doors. It's less commonly known, and essentially, if one of these exemptions applies, which most of them don't apply to library boards, so there's really only going to be one that comes into play. Of these three exemptions, only one comes into play for most library boards. But if one of these exemptions does come into play, it's as if the open meetings law doesn't exist. You can throw all of the requirements of the open meetings law out the window. The first of the exemptions is judicial or quasi-judicial proceedings, except for proceedings of the Public Service Commission and zoning boards of appeals. So if your library board has been granted the authority to hold a hearing on a particular topic, and the results of that hearing will represent the final determination of the library board of trustees, that may be considered a quasi-judicial proceeding that can be held outside the scope of the open meetings law. It's just not a very common thing in the world of libraries. And Rebecca or anyone else can correct me if I'm wrong, but it just doesn't come up that often. The second bullet also doesn't come up very often in the world of libraries because most library boards, people don't run on political lines. But for example, if you had any sort of public body that had a mix of maybe it's a town board with 3 Republicans and 2 Democrats. Even though those 3 Republicans might represent a quorum of the town board, they're permitted to meet whenever they want and talk about whatever they want because those political committee meetings are exempt from the requirements of the open meetings law. They can't vote. They can't vote on behalf of the town board or whatever the public body is, but they can talk about whatever they want. The third exemption is the one that could possibly come up in the world of library boards of trustees. And this is where a conversation that is confidential under either federal or state statute. So for example, if you're having a conversation that relates to library patrons that's made confidential under Civil Practice Law and Rule Section 4509, that conversation is confidential under state law and could occur behind closed doors. If you need to meet with your library attorney for the purpose of requesting legal advice and your attorney is meeting with you for the purpose of providing that legal advice, that conversation, and it's very limited to the portion of the conversation where the attorney is receiving the request for legal advice and providing the legal advice. It has to be a conversation that's covered by the attorney-client privilege. That conversation is also confidential under New York State civil practice law and rules and can be held behind closed doors. There's no obligation to have these sort of exempt meetings within the confines of an open meeting, but sometimes it happens that way anyway because it's most convenient for the body. You don't need to make a motion to go behind closed doors when it's an exempt conversation. I just recommend that you notify the public why you're leaving the room or why you're kicking them out, just as a courtesy. There's no obligation to have that very specific motion like there is with executive sessions. You just as a courtesy, you're going to want to let them know we need to go, meet with our attorney to get some legal advice. So we're going to step behind closed doors for about 10 minutes and then we'll be returning, something along those lines. So those are the exemptions. I know earlier, I think we brought up briefly, but before I go into noncompliance and enforcement, I do want to circle back to a topic that came up sort of a little bit earlier, but I didn't dig into it very deeply. It's very important to remember that any time a public body gathers for the purpose of conducting public business, and that's pretty broad. When I'm talking about conducting public business, I'm thinking about it in a very broad sense, and the courts are going to look at it in a very broad sense. Anytime you're discussing public business, anytime you have a quorum of the public body that has gathered to discuss or conduct public business, and this includes those brainstorming sessions, it includes work sessions, it includes agenda sessions, it includes sometimes you'll see people talking about retreats. Okay, well, what are you going to talk about at this retreat? Is it team building exercises that is generic to all individuals, or is it really just a way for a public body to talk about library business? Anytime a public body has gathered to discuss and conduct public business, those conversations must occur at a meeting that is held in compliance with the open meetings law. So it's just very important to remember that when we talk about meetings, it's a very broad definition. It's going to encompass any gathering of the quorum whenever there's an intent to discuss public business. It does not include social gatherings. If you all are at a library party, that's fine. If I had a quorum of a board of trustees show up to one of my in-person trainings, that's fine, because they're not there to conduct library public business. It's the open meetings law is going to get triggered when that quorum gathers together for the purpose of discussing public business. Oops, I didn't mean to do that. I'm going to go see if I can go back. Probably not, but I'm going to go way down here. Oh, that didn't work. Oh, I did it again. Anyway, I'll keep talking while I Committee on Open Government is an advisory body. We were created by the Freedom of Information Law. I keep going too far. This is driving me crazy. We were created by the Freedom of Information Law in 1974 for the sole purpose of providing advice and legal opinions regarding the New York State open government statutes. We do not have enforcement authority. You are always any person, whether it's a government employee, government official, library employee, or you're a member of the media, or you're just a member of the public that is interested in in the Freedom of Information Law or the Open Meetings Law. You've tried to attend meetings and are concerned that the public body is not holding its meetings in compliance with the Open Meetings Law. Maybe you've made a Freedom of Information Law and you're concerned that the response you've received is not compliant with the statute. Those are the types of questions that we get all the time. We provide advice and legal opinions based on the plain language of the statute and judicial precedent. We're not advocates. We're not really transparency advocates. And I only say that because I know it might sound funny because this is what I do for a living, but it's important for people to understand that our office, our attorney, our staff of attorneys are never going to provide advice to a government agency or a public body encouraging them to do something that we don't think they're required to do under the statute. We're never going to tell a public body that they must do more than was required under the statute. Our role is to provide you advice about what you are required to do under the statute, and what the courts have said in areas that are a little bit more gray. Just got to turn a light on because apparently it decided to go automatic on lights. No lights. Trials of working from home sometimes. Things not quite as, never as smooth as I hope. So that's just, I just always want people to understand, part of the reason why I reinforce that is because sometimes I am concerned that there are levels of government that hesitate to reach out to us because they're afraid, well, what if they tell us to do something that we don't really feel comfortable doing or that we don't want to do? And that is entirely your right. I can give you advice that I think is completely based sound judgment based on a plain reading of the statute and what the courts have said, and you are 100% free to disagree with me. I have no authority to issue counseling memos. I can't force anyone to do something, force any government agency to do something that they don't want to do. Enforcement of the statute is through a CPL or Article 78 proceeding. Any aggrieved party can bring an Article 78 proceeding to attempt to enforce the open meetings law. If the petitioner prevails, the court has the authority to award costs and attorney fees. They could potentially invalidate actions if the court finds that those actions took place at a meeting that was held not in compliance with the open meetings law, or potentially as a result of discussions that occurred outside of a meeting that was held in compliance with the open meetings law. But the courts are really only going to invalidate actions if they find that there is a substantial violation. If they find that there is mere technical violations, the courts are not going to invalidate actions. And I'll give you an example of something that's come up kind of a couple of times in the past year or so. We've seen situations where the lawsuit, maybe the whole one element of a petitioner's lawsuit might include concerns that public bodies are not posting their records scheduled to be discussed at least 24 hours prior to the meeting. And the courts aren't happy about this. The courts are saying, no, you've got to do this, please. This is a court order. You've got to comply with it going forward. You need to be posting your records scheduled to be discussed at least 24 hours. But they have declined to invalidate actions that were taken relating to conversations relating to those records, if that made sense. They found that failing to post those records was a mere technical violation as opposed to a substantial violation. I would imagine, like, for example, a substantial violation might be having secret meetings where you do all the bulk of the deliberations and then you just show up to the meeting and all you do is vote. I can see the courts would find that to be a substantial violation of the open meetings law, where they would likely invalidate the actions taken. Another penalty is getting forced to take training from me, but a lot of people do that voluntarily, so I don't know how bad it could be. So I've come to the end of my presentation, and now we have time for Q&A.
Thank you, Kristen, and thank you to our audience for letting us know that view wasn't ideal. I'm sorry we couldn't make it better for you. We will definitely troubleshoot that for next month's session with Kristen. We've had questions flying fast and furious. Brian and I was just saying to Brian, these questions are solid gold, and they're really going to reinforce a lot of what Kristen just brought to us. I know some of you were complaining about the view, right as Kristen was saying, the critical information about committees and do they fall under open meetings law? So Kristen, just to warn you, we're definitely going to have to ask you about that again because we had
No
a ton of
problem.
questions come in. But Brian, do you want to start us off with the question that rose to the top for you? I know you've got some that came in beforehand before we
Sure.
get to the live questions.
Sure, yeah, and like Rebecca said, questions are fantastic. I think this is the most questions we've ever gotten in
Yay.
Trustee Handbook Book Club. So congratulations, Kristen, to
Woohoo.
that accomplishment. I was checking off the boxes and some of the questions that were pre-submitted, so we're not going to get to all of them, but I do want to get to some of them. So the first question is regarding executive sessions. Is it correct to say that executive sessions are not strictly limited to board members? Can the board invite persons who have a stake in the topic of the meeting to attend the executive session with them?
Great question. And that is true. There's language in the statute that says the only people that have a statutory right to be present at the executive session are the members of the public body. However, the body may choose to invite anyone they desire to join them, whether it's, for example, the executive director might be asked to join in the executive session, or it could just be, it could be maybe somebody who's subject of an investigation, or it's maybe somebody who's being interviewed. There's all sorts of examples where somebody who's not a member of the public body gets invited into the executive session, and that is permitted.
Brian, do you want me to go next? All right, cool.
We'll alternate. Yeah.
All right, cool. So we have, so Brian, I'm going on the ones that got submitted in advance, right? Yeah. All right. So our board has 7 members. If the policy committee has 3 members and meets to review policies and make recommendations to the board, is this meeting subject to open meetings law? Does the meeting date need to be posted? Are the minutes required? This committee has no decision-making authority and only prepares documents for the board to review. Thank you in advance.
So it's a good question, and I know that was part of that conversation we were having was when we were having some technical. Well, we continue to have technical difficulties, but the answer is going to depend on whether you're a public library or whether you're a free or association library. So we'll start with if you're a public library. If your library is government funded, if it's a school district library, if it's town, city, village library, whatever the case may be, if your board of trustees meets the statutory definition of public body under the open meetings law, then the answer is yes. That policy committee, all of its meetings have to be held in compliance with the open meetings law, even though they may be purely advisory, if your policy committee is made up of 3 members of the board of trustees. So the answer to that is yes. If it's a public library, the answer is no. If it's an association or free library, a not-for-profit library. Again, going back, and I don't mean to, repeat myself unnecessarily, but the distinction there is the only reason free or association libraries are required to comply with the open meetings law is because there's a provision of New York State education law that makes it so. So free and association libraries, their boards don't really meet the definition of public body under the open meetings law, but education law makes them comply with the OML anyway. But education law also says that the only time those committees or subcommittees of the library board of trustees have to comply with the open meetings law is if you're located within a city with a population of 1 million or more, in other words, New York City. So I'm going to guess most of the people here don't really need to concern themselves with that. So free or association library committees do not need to comply with the open meetings law. Public libraries, they do.
Thank you.
All right. This next question, Kristen, if a trustee believes a violation of open meetings law is ongoing, what is their recourse if the rest of the board won't listen? So it sounds like you have a trustee that's trying to do the right thing, trying to do all the things that you've talked about here with us tonight, but maybe not all the best practices or all the boxes are being checked. Like, how should a trustee go about? Like, should they call you? Who should they talk to get everybody going down the right path?
And the first thing of course you would recommend is just vocalizing your concerns to the rest of the board member. That's the first step. Just letting the other board members saying like, hey, I've been reviewing the open meetings law. I think we're falling short in a couple of areas. Let me point your attention to this requirement that I don't think we're complying with. All of those great things. the second step, I think, is perhaps reaching out to us. If you think that getting input from a somewhat neutral third party, I don't know that we can be characterized as neutral, but to the extent that we can be, where this is my life, this is my professional life, this is what I do for a living. If you think reaching out to the Committee on Open Government and getting guidance, written guidance perhaps, that you can share with your fellow board members, if you think that would be helpful, then I certainly encourage you to do that. If you would like something in writing from our office, advising you whether certain activities are compliant with the open meetings law or not, and you'd like that in writing from us, all we would just ask is that you pose your questions in writing. It doesn't have to be fancy. You don't have to formulate any sort of legal memo. Sorry about the dogs. You just need to pose your questions, and we will respond in writing. We were just talking before about the dog that didn't stop barking. Just pose your questions in writing, and we'll respond in writing, and you would have that to share. The final last option is obviously not ideal, but it is litigation. It's if ultimately you feel like you're banging your head against a wall and nobody is listening, regardless of how much you've tried to push to try to get them to change their actions, and you feel it's really necessary to just not let it go, an Article 78 proceeding in state Supreme Court against the Board of Trustees, even if you are a member of the Board of Trustees, might be the last option.
Kristen, let's talk about locations of meetings. What are the criteria for a location to be qualified to host an open meeting?
Oh, that's a good question. The language in the statute talks about two aspects. One is that it has to essentially be ADA compliant. It has to be able to accommodate those with physical disabilities. And the second is that it has to be large enough to reasonably accommodate the size of the crowd anticipated to attend the meeting. So, for example, if you have like a really hot topic issue and you normally hold your meetings in a tiny conference room, you might want to consider seeing if you can, borrow the high school library or something a little bit larger, a larger conference room, whatever the case may be. So you just want to keep that in mind. You don't want to be accused of trying to artificially limit attendance at an open meeting by holding it in a small location. And of course, in terms of ADA compliance, you want to make sure those with physical disabilities can attend as well. Those are the requirements.
So I think that's pretty notable given the fact that the state library's recent audit of state library buildings or library buildings across New York State, 60% are not compliant with the Americans with Disabilities Act. So as we start to think about appropriate places to hold these meetings, making sure they're inclusive of all members of our community, some boards on this call are going to have to think about an alternative location. So that's really critical information. Brian, I think we want to switch over to our live questions that have been coming in, which I'm really excited about.
Yes, I'll jump around a little bit here, Rebecca, and then we'll answer live so that we take it off our list. But Kristen, I'm going to combine two questions because they're about the same, but each question is trying to get at a completely separate idea. So first and foremost, you've already talked about this a little bit. So board retreats or continuing education, when a board wants to come together and just go through professional development, maybe participate in trustee handbook book club or something like that. Does that fall under open meetings law? And then also, if it does not fall under open meetings law, what happens when the board starts talking about things that they could potentially be taking action on a board meeting? Do they just stop the conversation? How do you develop the outline for that type of training so that you're not crossing over into that gray or in that gray area?
Yeah, that is important because certainly we don't want board members to feel like that they can't go to training or can't go to programs like this, even if they were, live or in person. It's not really relevant. It's just the distinction is, are they discussing public business? That's the most important distinction. If they are there for team building exercises, if they're here for educational purposes, if they're, so a program like this, a program on New York State education law, a program on improving library services, anything like that, where it's just sort of just not specific to your library, just generally like sharing ideas within a larger group of like-minded individuals. Or if you're at the holiday party or the 4th of July barbecue over the summer, it's fine for you to all be present at those locations. It really is. but you do need to refrain from engaging in conversations relating to your role as trustees. Any conversation that relates specifically to library business, you just need to stop yourself. You need to self-regulate. There is a level of trust that we give to all of our public employees and officials because we can't follow them around all the time. We can't know what they're doing every moment. So we do have to trust, give them, work on the honor system that they are doing the right thing. And I do have faith that a large percentage of all government officials and are doing the correct thing, or it's at least their sincere intent to do the right thing. So sometimes it's just a matter of sometimes a conversation starts to veer in a certain direction. You just one or more of you needs to say, "Hey, we gotta stop. We gotta stop having this conversation. We'll continue the conversation at the next meeting of the board."
So, Kristen, a question that frequently comes up in my area is related to the newspaper, right? We have to send notice, and you were super clear. You don't have to buy a legal notice, but you have to prove you've sent the meeting locations to your newspaper. And we reminded folks that they should be naming a newspaper of record. Where could someone expect to find information about the library? But we've got a number of towns in upstate New York that just don't have a newspaper anymore. What's your advice to them?
Understood completely. It's another option. I mean, we talk about the media, and again, most times we think about the newspaper as being the media. It may be other options available. It does have to be paid media. Like, for example, it can't be like a penny saver or a blog, or blogs aren't even a thing anymore, but like it can't be, and it can't be really even like Facebook. Sometimes they're like, well, isn't, Facebook's the media, right? No, Facebook's not the media. It has to be paid media. So sometimes it could be, for example, if you have Spectrum coverage, Spectrum News coverage, that might be an option, is just finding a reporter who does local coverage for your area and developing a relationship, and they're the person that we send the notice to. Sometimes it's just, no, there is no local newspaper here, so maybe we're notifying it's a larger news source that, like, the closest city to you. To be perfectly honest, I think in this day and age, notifying the media is less about giving the public an avenue for finding out about the meeting and more about letting the media know that a meeting's going to occur so they can go. In my opinion, and I'm going to guess most of you would agree, is that the most common way that people find out about meetings that in this day and age is through the internet. They're going to go to the library website. They're going to go to the library website, or maybe even the library Facebook page. But I would reinforce that in general, like a Facebook page, an Instagram page is not the same as a web page. But that's where people go to find that information. So I think I would encourage really focus on making sure that information is available through the websites, maybe, and again, not mandatory, not mandated by statute, but if you do have a social media presence, take advantage of it, get the information out through social media. But there's nothing in the open meetings law that really helps locate, as smaller newspapers are becoming less and less frequent. How do we deal with that? I think the best thing that you can do is say, okay, who do I know that covers local government? Like, for example, do I know, let's see, if I go to your school district, who covers the school district meetings? Maybe that's who you use for your contact. Who covers my local town board meetings? Maybe that's who you use. I think you can use those resources at different levels of government and find out who they use and just glom onto them.
Those are good tips. Thank you, Kristen.
Kristen, can you talk a little bit about, so you did a really good job of going over the requirements of what allows a trustee to participate in an online forum. You talked about the policies that need to be put in place. What happens if a library board doesn't have those policies in place and the person doesn't have an extenuating circumstances? So like you said, being on vacation isn't one of those criteria that meets that requirement for being able to participate online, can they still join the meeting and listen in and participate on the discussion, or can they just not listen at all? Can you talk a little bit about like what that person who's joining remotely on vacation can or cannot do within that meeting setting, particularly if they're not disclosing their location or anything like that?
Right? If they're not disclosing their location, which is a good point, because earlier when I was talking about video conference, I used the more typical example of a statewide board that has, people all over the state. But another scenario that has been occurring for the past 20 some years is maybe you've got snowbirds on your board. And that happens. You've got town boards, library boards where some of your members might go down to Florida or Hilton Head or whatever for 3 or 4 months during the year, but they still want to participate in meetings. If they are willing to provide either their location at home, or maybe they also go to a local library and borrow a conference room at the local library, and that's the location that they use to set up a video conferencing. Like they set up their laptop and they video conference into the meeting using their laptop. They can fully participate and vote as long as they're willing to provide an address and location that can be included in the meeting notice. Do I think anyone's going to attend from those secondary locations? Absolutely not. I just think they still need to comply with that statutory obligation of making it an open location. So the person on vacation can still participate, but there's just, again, other hoops that they need to jump through. They need to find a location that's accessible to the public, and where the address can be put in the meeting notice. So for example, if you're in your car, that's not an option. You can't provide an address from which you're participating if you're driving in your car. If you're in a hospital, you cannot participate remotely from a hospital room, because you can't just have people walking into the hospital.
They only let 2 visitors in at a time anyway.
Yeah, exactly. So, but assuming that's not the case, assuming that you have somebody who it's not feasible for them to make their location open to the public, or they just are not willing to make their location open to the public, which is understandable. In that case, they really just can't participate at all. It's not that they can't vote. They can't participate even in the conversation. They can't be there.
Kristen, we had a couple questions that came in with some nuanced scenarios they created around using executive session as it pertains to the search for a new library director. The library boards are tasked with hiring just one employee, technically, which is the library director. Okay. And I think some people are struggling with what's too much personal information to share, when can you use executive session to vet a candidate as a board, are interviews of a director considered an open meeting? So could you help us sort that one out?
Sure. So I think let's take it from the beginning. You've put out a request for a resume, you've posted the position, and you've received 100 resumes. And now you've sort of got to sift through them, and maybe at one of the meetings, everybody's had an opportunity, maybe they've all had an opportunity to review through the resumes at home. And now you go into an executive session because you're going to make a motion to go into executive session to discuss the employment history of multiple individuals who have applied for the position of executive session. That would be an appropriate motion to go into executive session. And the board members can then go in and discuss the employment histories that are reflected in the people's resumes. Maybe you're going to narrow it down. Everybody's going to suggest their 5 top candidates or their whatever, and everyone's going to maybe come to an agreement about who they want to move forward with in terms of interviews. The next steps. That would be appropriate conversation for executive session. In addition, interviews themselves can occur in executive session. So it might be a little bit procedurally awkward because you do have to have an open meeting, but you'd have the open meeting, you make a motion to go into executive session, and then you all move to maybe a secondary location where the candidates are sitting at different points. Like maybe they're set up at half-hour interviews or hour intervals, whatever the case may be. Maybe it's all even at different times, but you can have those interviews because you're discussing the employment history of a particular person and you're discussing matters leading to the appointment of a particular person. So all perfectly acceptable things to do in executive session.
Great. Thank you.
Kristen, when folks go into a board meeting to talk about, oh, I'm sorry, let me back up for just a second. You mentioned during the presentation that any board documents need to be posted to the website. Can those documents be taken down off the website after the board meeting?
They can. There's nothing in the statute that talks about how long they need to stay up there, as long as they were made available up until the point of the meeting, while the meeting. The goal of this provision is really to allow the public to follow along with the conversation. So the reason why this provision was added to the open meetings law was so that when you have a board of trustees or you have a town board, village board, city council, and they're up at the dais discussing the documents that they're sitting there looking at, this provision allows the public to be following along with the conversation. So that's really the goal of this provision. So once the meeting has occurred, there's really no obligation to continue to have those records be posted. Sometimes it just occurs. It depends on your record keeping system. Sometimes they just stay up on your website as attachments to an agenda. That's fine. But once the meeting occurs, they can, in theory, come down.
And what about board meeting minutes? So obviously those have to be up after the actual board meeting and stay up. Is there a records retention requirement for how long they're supposed to be on the website?
For the website, I'm not aware of any record retention period. There's nothing in the open meetings law that says how long they need to stay on the website. My informal opinion for people that have asked me is at least a year, but there's nothing in the statute that says that. I just think it's probably a good rule of thumb. And then, of course, there's always the understanding that they're available upon request at any point.
Sure.
If they come down off the website, somebody can always make a request for copies of those meeting minutes. But the statute itself doesn't address it. And while I'm sure there's record retention requirements for meeting minutes generally, I just don't think they apply to how long they need to stay on the website.
And that does speak to a little ad we can make here for our session in February, which is on freedom of information law, which touches on records retention and being able to supply something that someone requests that might not be on your website that's legally required. Yeah. So a follow-up question on documents, if it's okay, Brian. We had several questions come in related to financial documents that might be discussed during an open meeting. For example, a bank statement or the warrant list. Are those things that you would say need to be on the website because they're going to be discussed? Can they be redacted to salvage concerns about someone having the bank account number? Any advice on the financial records front?
Yeah, anytime that the board intends to have any sort of conversation relating to a particular record, that posting requirement is going to apply, but you are permitted to redact any portion of the record that you feel should not be disclosed. Like, for example, if a FOIL request was made for that same record, you could, and you would redact certain portions of that record too, whether it's a privacy concern or whatever the case may be. If certain portions of a record would be redacted prior to them being disclosed in response to a FOIL request, those same redactions could be made prior to them being posted online.
All right. So I believe this is a good question because I know that it did take place of a board many, many years ago when I first became a system director. But I know you already have the answer to this right away, Kristen, but can a library board meeting be at a person's house for an executive session without telling anyone except for board members? And I think it's good to bring it up just because it is being asked within the session.
And the answer is no. In order to have a meeting of a public body, you need to in order to have an executive session, you must first have a publicly noticed open meeting at a location that meets that ADA compliance requirement, as well as be able to accommodate the size of the crowd that they anticipate wanting to attend. So the notice has to go out. The public has to be allowed to attend the meeting, and then you can make the motion to go into executive session. So a standalone executive session, a 100% standalone executive session is never going to be permitted. And really having a meeting at somebody's home is never a good idea. It's just not.
I think it's worth going on the record for, though. So I think that's good.
100%. I think
Just say it out loud, Kristen. As someone who's been invited to those meetings, it's always a little awkward.
Yeah.
We had a couple questions.
That is part of the aspect of it is is people, members of the public who are going to a meeting should feel a level of comfort and not feel awkward about going to a meeting, about like, maybe, sitting on somebody's couch or trying to find some place, it just could certainly, like, it's awkward. The other questions have come about having a meeting at a restaurant. No, you can't have a meeting at a restaurant, even if it is ADA compliant and large enough to accommodate the size of the crowd that wants to attend, because when you go to a restaurant, there's an expectation that you're going to buy something. So, like, you're going to have, pay for a drink, pay for food. And there should never be that sort of that imposition on somebody who just wants to attend a meeting of a public body.
We had a couple of questions that came in about quorum and what happens in both directions. First, what happens if you've got an open meeting, you've announced it, we all show up for that meeting, and what do you know? Not everyone showed, and we don't have a quorum. Folks are asking, well, can we still have a little chat, but we just can't vote? Should we just say, oh, better go to our backup date? What do they do in that moment?
Go home. go to your backup date. Don't even start engaging in any sort of conversation, even if there's no intent to vote. The conversation itself is a meeting subject to the open meetings law, and there's no authority for a public body to engage in those conversations collectively unless you have a quorum present.
So follow up to that are questions about, we have a board that has a committee. The committee roster is less than a quorum, totally legal, but other folks on the board are really curious about a topic they're going to discuss at that meeting and show up at the committee and push them over a quorum. What do they do in that situation?
So this is a really good question. Is what I recommend is, because it's a meeting, if we're talking about a public library where the committee meeting is subject to the open meetings law, those other board members have a right to attend, have a statutory right to attend. What they need to do is sit in the audience and zip it. Keep their mouths shut. Do not engage in conversation. Do not start engaging in a conversation. You shouldn't have anything to add. You shouldn't be involved in the conversation that was designated to that committee to handle. If there's a time set aside for public comment, which often isn't the case with the committee meetings, but if for some reason there is, I suppose those members also have the right for public comment, but you can't give the other board members any additional privilege than you would give to any other member of the public. So if the non-committee board members want to go to the meeting, they have to be allowed to go to the meeting, but they really do need to just sort of sit against the wall or sit in the audience and zip it.
How about for an association a library committee where that committee didn't fall under open meeting law, but now that attendance number has pushed them into an open meeting?
There, it's going to really come down to an honor system issue, is because the committee meeting's not subject to the open meetings law. The other board members don't have a statutory right to be there. My recommendation would be for them not to be there. But it's hard to say, because and if for some reason they chose to be there, again, they just have to sit there and zip it. So, and it's so hard to do, especially if there's no oversight. The public isn't at this meeting. There's no oversight. There's no one to, like, to give them a slap on the wrist or a reminder if they start engaging in conversation. And it's, under those circumstances, a little harder to self-regulate. So what was intended as a meeting of the committee is much more likely to turn into a meeting of the entire board of trustees if there isn't that external oversight of it being an open meeting. So I guess my first instinct would be to recommend that non-committee board members don't attend if they don't have a statutory right to do so.
Thank you.
Excellent. And just to let you know, we've been getting some private messages too from the attendees letting us know that we really appreciate us answering that question on whether or not meetings can happen at home. So I'm glad we answered it.
I'm
Yeah.
glad. No.
Yeah. I think it was good. I think we have time for one or two more questions. I'll go ahead and ask my question first, and then Rebecca will go a little bit over time, get one more from you, and then we'll close out for the evening. We do want to be mindful of everybody's time. This next question is in regards to if you've got folks that are attending, oh, sorry, I just lost it. Oh, I'm sorry, guys. Rebecca, can you go ahead and answer your question? I just lost mine. Sorry, I didn't mean to put you on the spot like that.
Oh, no problem. I just
Yeah.
was scrolling because there's so many good ones to
I
pick
don't,
from.
yeah.
So, just a reminder to folks at the end of each season of Trustee Handbook Book Club, we do another session where we answer all the questions we didn't get to. But we're also going to give you some follow-up information in the follow-up email that not only has Kristen's slides, but also a link into the Committee on Open Government website, which has a phenomenal catalog of opinions that are written where you can like go in and say association libraries committees, and you get that answer, that reminder. There's also a good FAQ we're going to put right into that follow-up that summarizes some of the most common issues that come up about committees and video conferencing in particular. So Brian, I think why don't we
I'll,
wrap up there and
yeah.
we'll help everyone get connected with the other dates coming up in the series.
Yeah,
Um,
absolutely.
but I just want to, my final thing I'd like to say is thank you, Kristen. I think that the comments I'm seeing make it clear this is a very good use of people's time. They really appreciate your help in helping them do a good job on behalf of their community. I think people want to do the right thing, and they're trying hard to understand this law.
Yeah. Well, thank you for having me. I always appreciate, I always like meeting up with you all. You're a great group. Thank you.
So both Kristen and Rebecca, thank you guys very much, and thank you everybody for joining us tonight. It was a wonderful conversation. We want to thank you for your thoughtful questions and sharing your experiences. That's what makes these sessions so valuable. Just as a reminder, everything that Rebecca just shared with you, all of our recordings, our resources, our registrations for upcoming programs are available 24/7 if you just go to the midhudson.org/trustee book club website. Additionally, please take a look at all the sessions that we're offering in 2026. We got at least 4 more sessions happening in February, April, June, and October on the subjects of freedom of information law, hiring and evaluating a director, laws and regulations, duties and responsibilities of key office roles. And then also we've got new sessions for new directors or directors out there, which will be launching coming out of the Director Handbook Book Club. This kicks off in March with 4 sessions to follow, including what's new in the new director handbook, getting off to a good start, the director board relationship, and the library network in New York State. In the meantime, we hope all of you keep up doing the great work that you are doing with your communities. We really appreciate your continued dedication through amazing governance work, particularly during this very challenging time. Be well and take care of each other, everyone. We'll see you next time. Thank you.